Next case set for argument this morning is Humphries versus Lorain City School District, case number 18CA011380. Both parties are present, so we will have 15 minutes to present your arguments this morning. The appellant may reserve up to 5 minutes for rebuttal. If you are going to reserve, let me know and I'll keep you apprised.
Would you like to do so, Your Honor?
Okay, we'll get to you in 1 second here. We ask that you remain at the podium and keep your voice up because we do record the arguments and they're posted on the court's YouTube channel, so please do that. We have read the briefs and we are prepared to proceed if you are. You say you will be reserving time?
Yes, Your Honor.
How much would you like? How long would you like to reserve?
3 minutes, Judge.
3 minutes. All right, you may proceed. Go ahead.
May it please the court, counsel, I'm Avery Freeman and I represent the plaintiff appellant Aliceson Humphries. This case involves the termination of my client, who is a long-standing, high-performing administrator in the Lorain City School District. In November of 2017, this court reversed the trial court for its abuse of discretion in 2 respects. Number one, that the manifest weight of the evidence in some fashion supported the district, and number 2, that it applied due deference. That reversal resulted in our filing briefs, and in July of 2018, the lower court wrote an opinion in which it essentially reaffirmed that the manifest weight of the evidence supported the school district, and that due deference to the hearing examiner was granted. What's especially interesting about the remanded decision, it's 2 pages, is that the court concluded that it agreed with the school board that the hearing examiner, who oversaw a proceeding which involved about 900 pages, ignored 4, quote, unbiased witnesses. Well, interestingly enough, the school board was not in a position of determining bias, credibility, veracity, nor was the lower court. The only trier of fact that heard witnesses was the referee from the ODE, agreed upon by both lawyers, that assessed the credibility of witnesses. And on remand, what the lower court did is to say these 4 witnesses, there's no identification of who those 4 are in some fashion unbiased. In fact, what the trial transcript required, and what we believe this court meant in reversing and remanding, was to assign discernment in the record. For example, in this case, there were 8 witnesses testifying over a 4-day period about what really happened that day. And 2 witnesses in particular, which is not mentioned at all by the trial court, was with 150 people in the stadium that fateful day on the 6th of May, 2015, were a number of students. The district made no effort to get the facts. What they did is they counted on their staff attorney to interview 2 individuals, and that was the basis of their case. No one other than the referee tested in the crucible of examination and cross-examination the veracity, bias, forthrightness, lack of forthrightness. And so if the trial court truly concluded that the manifest weight of the evidence shifted to the school board, there's nothing in the opinion written by the lower court that says that, other than identifying 4 unbiased witnesses. This case is particularly significant because of the stark difference between the state of the record, the 900 plus pages, and the question of due deference and manifest way to the evidence. The other thing that's silent on remand, excuse me, is that there was testimony from an educational expert, Dr. Tracy McCauley. And Dr. McCauley, as superintendent of the public school system, reviewed the facts and made a determination that if there's going to be punishment, it would be excessive or extreme or disproportionate to fire this administrator. That, of course, is the professional death penalty of an individual who worked diligently and had the toughest job at the school district, and that was caring for at-risk children. And the abysmal record of public education in Lorain, one of the bright spots was Alice's program at the Digital Academy in helping at-risk children. There's also a reference in the remand opinion by the lower court that talked about an incident in 2009. Well, an examination of the 900 plus page record shows that there was no evidence about that. And the court assessed the credibility of one witness, Mr. Giardini, and rejected it. So in terms of the record itself, the question really turns is, was there violence by my client at the track meet on May 6, 2015? What we heard from Michaelia Jones, what we heard from Mr. Yannaris, what we heard from other witnesses who were there and heard what people were saying, as opposed to the two witnesses who could hear nothing, was that it was my client that broke up the fight between a very out-of-control mother and her daughter. And those two people were my client's sister and niece. And after the matter was over, she admitted that she bopped her niece on the head, bopped her on the head. Lorain overstated it, distorted it, perverted it, and suggested there was violence which warranted termination. An extreme and frankly corrupt determination based on the state of the record. Ms. Humphries was very forthright about what happened that day, and equally so, and it's silent in the remand opinion written by the trial judge. The perpetrator of the violence, the mother of the child, testified freely. Yeah, I dug my fingernails into her, and it was my sister Aliceson that broke up the fight. The other powerful piece of this, and you can't tell by the trial court's opinion, was we don't know what four witnesses were unbiased.
Mr. Freeman, can I ask you a question? Doesn't this all turn on whether the board was obligated, required to accept the referee's recommendation that she just be disciplined? Aren't you really arguing that the board doesn't have its own independent authority to make a determination as to whether that was appropriate or not?
That's right,
That's
Judge.
the whole thing turns on that.
Right, and it turns on the standards which this court has articulated. Does the evidence, manifest way of the evidence shift over to the board? Is that what the record really shows? And did the board grant due deference to the
Well, didn't
referee?
they grant due deference to the findings of fact that the referee made? Aren't those two distinct things?
I think they're interrelated, Judge Schaefer. I think if a school board is going to grant due deference
To the findings of fact.
on facts, well, frankly, I think 3319.16 is the discretion which the General Assembly gave school boards. And the due deference relates to both facts, and based on the assessment of those facts, the appropriate remedy. In this case, Dr. McCauley explained that given the fact that it was a bop by an aunt to her niece after the fracas on the way to the parking lot, that the death penalty, if you will, of firing an administrator would be disproportionate and excessive. So I hope I answered the question, Judge Schaefer. the due deference and manifest weight of the evidence are interrelated. I don't think due deference relates strictly to the facts, but by the judgment and recommendation of the hearing examiner, the only person who was able to put witnesses in the crucible of examination and cross-examination.
Counsel,
I'm sorry, Judge
I'm
Callahan.
not 100% sure that the expert that you purport was an expert was actually accepted by the court as an expert, but assuming that she was, does her opinion have to rule the day? Can it be accepted or rejected?
Yes, well, in using the standard of due deference, if the hearing examiner, after examination and cross-examination of the witness, assigns credibility, that's the function of the hearing examiner. How the school board can make a determination without knowing the issues of veracity, trustworthiness, credibility, strikes me as a virtual impossibility, because what the record shows is the extent to which Dr. McCauley understood the process, understood discipline, used her decades of experience to guide the hearing examiner. The whole purpose of Dr. McCauley's testimony is to explain that, and it was unrebutted, Judge Callahan. So I think when we're thinking about the interrelationship of manifest weight of the evidence, there is nothing that shifts the gravitas, the weight of the evidence, where Ms. Humphries was able to present 8 witnesses at the scene. In one case, Ridge Mitchell, according to the record, was only 15, I want to say feet or yards, 15 feet away from everything that happened. He heard everything, he saw everything, he testified. And both Mrs. Humphries, Alison's mother, and Jack Yanneris were 25 feet away. The 2 witnesses of the school board, one was on the other side of the pit, and the ticket taker was somewhere else, both admitting that they heard nothing. All they could do was they saw bits and pieces of it. So we believe that the court did abuse its discretion in failing to apply due deference, abused its discretion in failing to understand that the manifest weight of the evidence remained with the employee, and that there was nothing to support the idea of shifting it to the school board.
What recommendation did the hearing officer make?
What recommendation
Yes,
would,
ultimately, in terms of her employment.
I'm sorry, Judge, I didn't.
What ultimate recommendation did the hearing officer make in terms of
The
her
ultimate
employment?
recommendation, which the hearing examiner quoted Gilbert and Sullivan, which in some fashion offended Lorain. But the beauty of that citation was that there was cause, but that the punishment should fit the crime. And the punishment that fits the crime would not be the ultimate execution, and that is the termination of this employee.
But in this particular case, it wasn't just, the school board wasn't considering just this particular incident, isn't that correct?
Well, no, what the lower court did is extracted something back from 2009, which is not even part of the record. It was an allegation made by a witness, Mr. Giardini.
Is the school board able to consider its own files and its own records when it makes its own determination as to what appropriate discipline would be? It has personnel files in its own board office.
It had access to certain information, but what's particularly significant about the lower court is that it is assigning credibility to 4 unnamed witnesses as a justification for shifting the entire manifest weight of the evidence.
Ms. Friedman, you've got 2 minutes total remaining, so.
Oh, well, let me,
Let you reserve that for rebuttal.
and come back, all right?
Sure, you go off 2 minutes on rebuttal. Okay, Attorney Giardini, you have 15 minutes.
Thank you. Good morning, Your Honor. My name is Anthony Giardini. I'm here on behalf of the Lorain Board of Education, Council parties. I think Judge Haber got it right. This case turns on the issue of what authority did the school board have under the circumstances of this case. And I think the law was recited pretty well by this court in its remand opinion when it sent the case back to the lower court. Obviously, this court was troubled by the fact that in Judge Moraldi's original entry affirming the board's decision, he made a finding or made a statement that the board had accepted all of the findings of the referee and then made its exercised its discretion and decided to terminate as opposed to following the recommendation of the referee, which was no recommendation, Your Honor. The referee said let the punishment fit the crime, which basically left the door wide open to the school board in our view. This court was troubled by the fact that the Judge Moraldi, had made that statement that the board had accepted all of the findings, and in fact, the board did not accept all the findings of the referee. So on remand, this court laid it out. You already laid out what the authorities are of the various parties. School board had to give due deference to the findings of fact of the referee and the recommendation based on those findings, and then make its decision. On appeal, the trial court had to review what the school board did to see if the school board gave due deference to the findings of the referee and to see if whether or not the school board's other independent findings or the findings that they rejected of the referee were supported by the greater weight of the evidence. And then, and this is most importantly, and I think it's the point that you made, Your Honor, and that is, but the real case turns on how these facts, which admittedly there are some conflicts in the record about the facts, and I'm going to address that in a second, but how do I take these facts as an elected school board member and interpret those facts in such a way to determine what the outcome should be, i.e. whether or not we should terminate this administrator's contract. That's what the case law says, it's what Aldridge says, it's what Graziano says, and it's what you said to the trial court. And then you rightly indicated that your review of the trial judge's decision on this matter is even narrower yet. A very narrow and rather strict view that you have to determine whether or not the trial judge, in doing his job, overseeing what the board did, abused his discretion. That's what the law is. That's what is required here. And now I'd like to talk just briefly about those facts, because while the appellant in her brief makes wild statements, conclusory statements about what the record says, our brief attempted to point you specifically to places in the record, in many instances, admissions by the appellant herself with respect to what she did, to point to you that the board could, based on that, make or reject some of the findings of the referee, and certainly had the right to look at those same facts that the referee looked at, that the referee himself put into his own decision, and say, based on those facts, if you're going to tell us, let the punishment fit the crime, then our determination as the elected representatives of the Lorain City School District, 4 of the 5 of those school board members voted to terminate the contract. And if you look at the resolution of termination of the contract, after the referee made his lengthy decision, you will see over 50 specific statements by the board in its resolution, 75 references to the 700 page record on this thing, 75 different references. It's obvious that the school board painstakingly looked at this whole matter after the referee did and made its conclusions based on that. And if Mr. Friedman is wondering who the 4 independent witnesses are, it's pretty obvious because I identify them in our brief, and it's pretty obvious to it was pretty obvious to the trial court who they were. Those 4 independent witnesses were 2 security guards who worked that day, a high school teacher who was also an assistant track coach who was there that day, and a person who was like a ticket taker at the entrance gate to the facility. Now, why do we call them independent? Because none of them were in the decision-making process with regard to Ms. Humphries. None of them had an axe to grind with Ms. Humphries. In fact, one of them was friends with her and had one time worked under her supervision. None of them had any reason to want to cause any harm to Ms. Humphries, to the student, or to anyone else. And if you look at their testimony, if you look at their written statements given prior to, during the investigation, and by the way, I didn't interview 2 witnesses and then they made a decision. The HR director, Carol Gotchlin, testified at the hearing. She interviewed 4 or 5 different witnesses, had statements from the student, had statements from Ms. Humphries herself, and Ms. Humphries herself had an opportunity to meet with then Superintendent Tom Tucker to give her side of the story the day after the event, and handed him a written statement the day after the event, before lawyers and other people had a chance to get together to talk about this whole thing. And her statement to the superintendent that the HR director heard and the superintendent heard, and in a meeting that I wasn't involved in, all determined that the statements that she gave were inconsistent with statements that she later gave after lawyers got involved and this thing became a big legal thing. And another thing that's very troublesome about the record in this, in his brief, Mr. Friedman argues that he presented 8 witnesses and 6 of them saw the events from start to finish. And those 6 witnesses were, well, of course, the appellant, her sister Natalie, her niece Marley, her nephew Keegan Ridge, her mother, Miss Humphrey's mother, and her mother's friend. Well, first of all, I would say just by that alone, these are not independent witnesses. By the time those folks testified at the hearing of this matter, everybody knew the serious nature of this thing. They were fighting for their daughter, their sister, their aunt's job. And what is most troubling is Marley, the student, when given an opportunity to give a statement about this whole event, a few days after the event occurred, wrote a very short statement. An opportunity she had then to exonerate her aunt from any wrongdoing in this thing. And her statement doesn't do that. But when Marley and Ms. Humphries and her sister Natalie and her mother and Jack, a friend, get together in Mr. Friedman's office, all 5 of them together, and give statements or prepare affidavits, all 5 of them together, then suddenly their statements are different than what they gave within days after the event. And worse yet, when they testified on cross-examination, their statements started falling apart. And I would encourage this court to read all of the testimony, the direct exam where they seem to have their stories together pretty well, and then the cross-exam where suddenly, on cross-examination, Ridge, Jack Daenerys, the senior friend, and Mom, when they were asked about the whole fight when it started, suddenly they got amnesia on cross-examination. Well, I looked away. I was too embarrassing. Ridge says, I was so embarrassed I just walked away. He didn't see the ensuing physical altercation. He might have seen some of the things that led up to it. He didn't see the ensuing altercation. Jack said he was so embarrassed, he walked away, turned away, and didn't remember this and didn't remember that. Well, wait a minute. If they saw everything from start to finish, how is it that their memory started getting? I suspect it's because they didn't want to lie for anybody. And rather than lie under oath, it's just like, well, I didn't see it, or I turned away, I was embarrassed. And right, they should have been embarrassed, because this was an embarrassing situation. And what's really troubling about this whole thing is everybody seems to blame Marley, the student. This was all her fault. I don't see anything in the record, and you won't either, where her mother or Ms. Humphries or anyone else went up to her and said, Marley, why don't you want to participate in the senior ceremony? What is the problem? No, you're going to do that, I'm going to beat your ass. That's what her mom said. And Ms. Humphries, her reaction to that was, go to the car if you can't behave yourself, to her sister. But when mom started to try to drag Marley, who had never been asked herself, why don't you want to participate? As if her opinion didn't matter in this thing. As if she was just some object of their glory. Mom wants to walk on senior night. Proud aunt wants to honor her niece, who's in track, and Miss Humphries was in track and had awards in track. No, this senior ceremony wasn't for them. It was for her. And nothing in the record indicates what. No, it's all her fault. It's all Marley's fault. Marley wasn't respecting her mother, who was swearing at her from the moment they got to the stadium. She didn't want to obey her aunt, who, in the record, Ms. Humphries' mother says, when Natalie goes inside the fence into the track to grab Marley to force her to walk in, and she's trying to pull her away from the fence. And what does Ms. Humphries' mom tell her? Her own testimony. Go help your sister. Go help your sister? How about go help your niece? Because it was the niece who was who someone was trying to drag to something she didn't want to go to. How about go help your niece? And if the intention was to go in there to just be a peacemaker and quietly tell Marley, look, just go to the car. Look at Ms. Humphries' own testimony. She handed the sweater that she was holding of her sister and a cell phone and the other things she had in her hands and gave them to her mother to go help her sister. Now, why need to do that? Why do you need to put a sweater down, a cell phone down, and the other things? Why not just walk in there? Marley, let's go, it's over. They've already announced your name, they've already said your bio, you didn't walk out there, let's go to the car. Because that ain't what happened. That is not what happened.
About 2 minutes left.
Thank you, Norman. What happened is more like what the two security officers, an assistant track coach who had no axe, who knew nobody in this whole event, who had no axe to grind, new teacher. The only thing she had to do was to try to protect her own student. And I defy anybody to challenge the credibility of a young teacher who's trying to protect one of her students, who would do anything other than try to protect that student, and why she would lie or make things up about about an administrator in her district is beyond me. Makes no sense. Those folks were independent. No, Your Honor, I would say to you, if we're talking about giving due deference to a decision made by a school board, we had an HR director who investigated this entire thing, recommended termination. To then Superintendent Tom Tucker, who based on all that evidence and listening to Ms. Humphries, made a recommendation to the board to terminate. And then a new superintendent came in while this thing was on appeal, Superintendent Jeff Graham. He looked at everything about this while this matter was still on appeal. He decided not to bring her back, not to end this litigation. Then a new CEO comes in, David Hardy, and he had an opportunity to look at this entire matter while this appeal was still pending. And he decided to hold it just the way it is and keep her terminated. 4 out of 5 elected school board members saw all this, read all the facts, read the transcript, and they made a decision to terminate her contract. And finally, the trial judge, Judge Moraldi, looked at the record twice, and 2 times agreed with the decision to terminate the contract. What else is the school board to do? If this doesn't warrant termination, if that's the message we're gonna send to our kids, don't fight in school, but it's okay for administrators to participate in a brawl, then we really have lost complete control. Thank you.
With that, your time is up, so thank you very much.
Thank you.
Attorney Friedman, you have 2 minutes then for your
Thank you.
rebuttal.
Interesting that Exhibit 58 in the record is a photograph which was shown to the security guard. He didn't know who Natalie was and who Allison was. Callia Jones, the independent student sitting in the stands, said by the time the guards walked over there, the battle was over. And Marley walked on her way back to the parking lot. So the idea of arguing facts here is interesting to me. In a sense, it's a concession, because the only one evaluating credibility was the referee. If the referee were granted,
Sir, I'm sorry to interrupt again, but the referee was only looking at the circumstances in this particular case.
Correct.
The board is looking at more, the employee's entire record too.
well, the entire record,
I'm talking
Was-
about 10
what was-
years worth of record, not just this case's record, but the employee's entire employment with the school district.
well, if that were true, then Ms. Humphries' record was an exemplary one. That wouldn't have helped the board in making a decision to get rid of her. The board had,
Hadn't she had a 30-day suspension back in 2009?
and there was testimony about that, Judge Schaefer, because Mr. Giardini made allegations, the superintendent, Dr. Atkinson, rejected that, brought her back to work as an executive in the higher level administrator. So by exploiting that or puffing that up to use that as grounds, again, this all came out at the trial. If the board members truly looked at the record, Judge Schaefer, then they would have seen that the allegations in 2009 had no weight, and that the allegation that Allison was responsible for a brawl was the opposite of what our referee heard in this case, and assigned credibility to the witnesses. I know Mr. Giardini is arguing, well, you shouldn't believe the witnesses, except the only one that assessed credibility was the referee. So in that respect, if 3319.16 means what it says, to protect the due process of school employees, of administrators, then that determination by the referee is the critical aspect. If it weren't there, there would be no due process. If boards didn't consider what the referee did, there would be no due process.
So you're suggesting because they didn't accept the referee's recommendation, which was to let the punishment fit the crime, that they didn't defer to the referee?
And,
Well,
excuse me, I'm gonna let him answer
required.
this, but you are over time, but I'll let you answer this question, but your 2 minutes has
All right,
expired.
let me respond to that. My position, Judge Schaefer, is that there's an interrelationship between due deference and manifest weight of the evidence. And that applies not only to determining the facts, but the referee, based on what he sees, the credibility of witnesses, understanding her long-term record, would come up with a recommendation, make the punishment fit the crime. And it was utterly disregarded, and essentially what the district has done today is try to re-argue the facts. So we believe, based on that, even with Mr. Giardini mentioned Mr. Hardy, a name that this panel doesn't know. The school district has gone into emergency academic distress.
I-
This,
That's outside the record, I'm sure, so
very well.
your time is up.
Okay.
It is up, so
All right,
thank you very much for your arguments, both sides. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail each party a copy of the decision on the day it's released. You can also check the Supreme Court of Ohio's website where those decisions are also available. So thank you both again for your
Thank you.
arguments.